And good afternoon, everybody. Welcome to the California Privacy Protection Agency public comment session on the data broker registration regulations pursuant to SB 362. My name is Liz Allen. I'm an attorney with the legal division, and here with me today is Gary Lee. He's a privacy fellow and an attorney, also in the legal division, and Serena Marzian with our public affairs division. A few quick reminders before we start. The session will run until 5 p.m. PST, and it is being recorded. A recording will be posted on our website at cppa.ca.gov. A reminder that written and oral public comments are treated the same by the agency. The agency will not be responding to public comment during today's session, but in accordance with the Administrative Procedures Act, all comments made today and/or submitted in writing by today will be responded to in the agency's final rulemaking documents. We understand there's a few people interested in potentially making public comment today. For the time being, we will be limiting public comment to 3 minutes per person, just to make sure we can accommodate everybody in our time. That said, if we get to the end of public comment and we still have time left, we'll invite folks to come back and continue comments if they had more statements to make. For now, we'll maintain the 3-minute limit, and we'll let you know once everyone with a hand raised has spoken, and we'll allow folks to come back. I just want to say in advance, thank you so much for being here. Today, we're looking forward to hearing your feedback. So with no further ado, I'll turn it over to Serena to moderate our public comment session.
Thank you so much, Liz. We are now open for public comment. To make a public comment, at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. I'll call your name and unmute you when it's your turn to speak. You'll have 3 minutes and I'll give you a 30-second warning. So it looks like we have one person's hand raised right now. Sorcy, I'm going to unmute you now and go ahead and speak when you are ready. I'm not able to unmute right now.
I'm also not able to unmute right now. Serena, we can see your full screen.
Now? Am I unmuted?
Yes, yes, we can hear you.
Okay, great. Sorry, thank you. Thank you. My name is Saoirse, and I'm a privacy fellow with a group called Oakland Privacy, which is a citizens coalition that works regionally to defend the right to privacy, enhance public transparency, increase oversight, and we specialize in the use of surveillance techniques and equipment, but we are obviously broader than that. What I wanted to talk about first is that we think that the section that requires data brokers to not only comply with the drop requests through the CPPA's page, but to do so every 45 days on an ongoing basis is an extremely strong part of this bill, and we think that it's really important. And we're really excited to see that that was present. Where consumers' privacy is concerned, the relationship between someone's personal data and a broker's pecuniary interest in monetizing those data is often deeply skewed in favor of the brokers. And this requirement returns some of the balance to shift back toward individuals and away from corporations. The next part was that in the introductory text to the Delete Act is this phrase: the bill would prohibit an administrative action pursuant to these provisions from being commenced more than 5 years after the date on which a violation occurred. But given that this is directly related to the effectiveness of the drop portal, I think it's important to consider how the timeline is measured. The CPPA ought to consider changing this from the date the violation occurred to the date consumers and affected parties were presumptively notified. To start the clock on the date of a violation, even if that clock runs for 5 years, focuses the attention on the actions of the corporations, whereas the rest of the bill's focus, the rest of the implementation of the drop portal, and much of the focus of the CPPA itself is on protecting consumers from harm. And that perspective shift, I think, is not insignificant. It mirrors a recent shift more broadly in the American social concept of privacy and personal identity, away from an industry-specific approach, which is largely dictated by the needs and desires of the commercial voices in those industries, towards something more closely resembling a European model, which places the attention on and centers decision-making around the locus of harm to the consumer. Following that important shift in perspective, the CPPA should consider altering the timeline from 5 years after the violation occurred to 5 years after consumers were presumptively notified of that violation. A smaller note too, and this is, a smaller note is that there's no direct link to the definition of the term dark patterns, which would implicate how, or which is referred to in how brokers use and respond to both these requests and also how consumers might be affected by data brokers.
20 seconds.
Okay. The very last thing that I want to add is that a month ago during the previous public comment period, a woman asked an important question. What is the actual harm to consumers from companies who erroneously remove someone's information from their databases? Brokers will try to paint the risk of removing someone's data without properly verifying their identity as profound, but it is not. The stakes are very low for consumers, and they are also very low for data brokers.
Thank you very much.
Thank you.
All right, Tony, go ahead and unmute you when you're ready to talk. Sorry, I'm unable to unmute. Can somebody else try, please?
Are you able to hear me?
Yes, go ahead, Tony. Thank you.
Thank you, and good afternoon. My name's Tony Ficarota. I am General Counsel for the Network Advertising Initiative, the NAI. And on behalf of the NAI, thank you for the opportunity to provide comments on this rulemaking initiative. In its initial statement of reasons for this rulemaking, the agency set out an objective of ensuring that data brokers provide accurate and adequate information to support the DELETE Act's goals of consumer protection through transparency and informed decision-making when exercising CCPA privacy rights. The NAI would like to highlight two opportunities for changes that would promote that goal. The first relates to the definition of covered reproductive healthcare data, and the second relates to the requirement for a business to indicate whether it collects consumers' reproductive healthcare data and/or their precise geolocation when registering as a data broker. To put our recommendations in context, we first note that the agency's practice has been to include on California's data broker registry page a business's indication as to whether it collects consumers' reproductive healthcare data or precise geolocation data. And that enables the public to view data brokers according to whether they collect those types of data. And this may help consumers prioritize which businesses on the registry to learn more about and to exercise their CCPA rights with. And so with that in mind, the first change the NAI recommends to the text of the proposed rules is to specify in the definition of reproductive healthcare data that it is sensitive personal information under the CCPA, which the definition currently proposed by the agency does not do. But by making this explicit, the agency can ensure that when a consumer makes a request to limit the use of their sensitive personal information to a business that collects reproductive healthcare data is sure to be covered by their request to limit. This change would also provide certainty to businesses seeking to comply with the DELETE Act and honor consumer requests to limit. Aligned with the agency's goals for this rulemaking, this change would promote informed decision-making by consumers when exercising their CCPA rights. The second change we recommend is to clarify that businesses registering as data brokers should indicate that they collect reproductive healthcare data or precise geolocation data only if they use those types of data for commercial purposes, and need not do so if they only process the data to delete, de-identify, aggregate, or render that data non-sensitive. Making this change would help consumers understand which businesses on the registry commercialize those types of data and avoid confusing them with businesses that may collect, but then immediately delete them. This too would promote informed decision-making by consumers when exercising their CCPA rights. It would also create a powerful incentive for businesses on the registry to minimize sensitive data that they don't use. The agency would not be alone in making this type of allowance, as there is strong precedent for doing so, both in self-regulatory standards set by the NAI, as well as recent enforcement actions by the FTC in the location data space. Again, thank you for the opportunity to comment on this rulemaking. Our recommendations are set out in greater detail in our written comments to the agency. Thank you.
Thank you. Okay, if you would like to make a public comment at this time, you can do so by raising your hand using your raised hand feature or by pressing *9 if you're joining us by phone. I'll call your name and unmute you when it's your turn to speak. All right, we have Yadi. Go ahead and speak. You have 3 minutes.
Hi there, I'm Yadi with Oakland Privacy. My colleague Saoirse made the comments that we had formally from our organization, but I wanted to take an opportunity to quickly address the comments made by the previous speaker from industry regarding reproductive data and the collection of geolocation. And I just want to remind the agency and others that yes, that is an interesting point about making the distinction of whether that information is used for commercial purposes. However, in addition, this data is also shared with law enforcement. And given the recent Dobbs decision and that we are finding that law enforcement is more and more going to tech companies and obtaining information, the ability for them to still be able to access very, very sensitive information like this is very troubling. And so I would just like for the agency to keep in mind that it's not just about making a distinction of what information the company itself is using for its purposes and also for commercial purposes, but also its ability to collect and share that data with law enforcement that is not covered by this. So I would just hope that this is something that's taken into consideration and giving the strongest protections to consumers and being able to control that data. Thank you so much.
Thank you for your comment. Okay, if you've already made a comment, you're welcome to raise your hand again, and you can speak since we don't have any other comments at this time. You'll have 3 minutes. So again, use your hand using your raised hand feature, or if you're joining us by phone, you can *9 and we will call on you. Thank you.
Hi,
Okay, Tony, go ahead. You have 3 minutes to make your comments.
Thank you again. And I listened with interest to Oakland Privacy's point about law enforcement uses. I think what you'll see when you read our written comments and some of the intent behind them, we're focused on businesses that are registered that limit their processing of data that would otherwise be considered reproductive healthcare data or precise geolocation data in order to minimize it. So different methods for minimizing it could be deleting it, could be aggregating it, could be de-identifying it, or could be rendering it non-sensitive. And in each of those cases, our point of view is that it would no longer have direct commercial uses in the form of precise location or reproductive healthcare data, and probably would not have any use to law enforcement if it's properly rendered non-sensitive or deleted or de-identified either. So I think it's an interesting consideration, and would be happy to have, some constructive dialogue on how to make sure that that would be accomplished by any allowance for the reporting requirement. Thank you.
Thank you for your comment.
Oh, yeah,
Darcy, go ahead. You have 3 minutes to make your comments.
great, thank you. So yeah, it's pronounced Saoirse, but what I wanted to talk about is, sorry, I'm also from Oakland Privacy, and my colleague Yadi just spoke. I wanted to talk about a different part of the bill, which is the part that reads, a data broker that fails to register as required by the section is liable for administrative fines and costs in an administrative action brought by the CPPA as follows: an amount equal to the fees that were due during the period it failed to register. Which, at the very high end of that would be $67,400, including like the fee and the $200 a day thing. And I wanted to ask how the I wanted to ask the CPPA to consider how that might be approached, and what the deterrent factors might be for a smaller data broker company versus a larger company like LexisNexis or Experian, for whom that might just be a drop in the bucket, and to consider what other enforcement mechanisms, for example, a sliding scale versus a daily fee or a daily penalty kind of thing, might have more of an intended effect of preventing companies from circumventing this requirement. And that's all that I have to say. Thank you very much.
Thank you for your comment. Okay, so just a reminder, we're here until 5 o'clock today taking public comment. So if you'd like to do that at this time, please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. I'll call your name and unmute you when it's your turn to speak. You'll have 3 minutes. Okay, we're taking public comments at this time. So please raise your hand using the raised hand feature or by pressing *9 if you're joining us by phone. I will call your name and unmute you when it's your turn to speak, and you'll have 3 minutes.
Thank you so much, everyone, for joining us. I'm letting you all know we have about 8 minutes left in this public comment session. We will remain open for comment until 5 o'clock p.m. Pacific time. And I wanted to encourage people to share their comments in the next 8 minutes if you have anything else you'd like to share. All right. Thank you, everyone who's continued to stay on with us until 5 p.m. We really appreciate you joining today's session, and we appreciate everybody who took the opportunity to provide comment. For more information and updates, please continue monitoring our regulations email, our board meetings, and regulations website at cppa.ca.gov/regulations. This session has been recorded, and the transcript will be available on our meetings website, cppa.ca.gov/meetings. We're at 5 o'clock now, so we will be closing the session now. Thank you again to everybody who attended and participated.